Good morning, friends. This is my 268th video, and this will be covering a speech which is very important. And for the first time, I'm making a video on this. This is the House Accommodation Act Bill 1889. This was prior to the 1899 Cantonment Code where land documents were to be made. Now, what does this bill say? Sir Honorable Major General Sir EDWIN COLLEN moved for a leave to introduce a bill to make better provisions for securing house accommodation for officers in cantonment. He said, for many years past, we have had under consideration the question of house accommodation in cantonments. In the early days of the British Dominion of India, the camps, stations, and posts of the field army developed into cantonments where troops were stationed in garrisons. These cantonments were located set apart for the troops and were intended for their use only. But as time went on, military persons were permitted to reside in cantonments under the regulation of the day. Land was occupied and houses were built for the accommodation of officers and for other purposes under the rules and conditions prevailing at that time. In later years, owing to various circumstances, great difficulties have been experienced in working the regulations applicable to cantonments, and the difficulty of finding suitable accommodation for officers, exceptionally for those obliged to live in a particular part of cantonment, have much increased. The whole question has been exhaustively considered by officers, specially appointed by committees and by other authorities. It has been discussed in every possible aspect, and the investigation has spread over a great many years. The present bill is the outcome of that discussion. The objections raised have been carefully considered, and we have recognized that the condition of ownership and tenancy must be governed by the regulation in force when any particular house was built. But as cantonments are and were intended for the occupation of troops, and as the whole of the land belongs as a general rule to the state, and houses were built in many cases by persons who had no status in cantonment, not for their own use, but as a source of profit. We consider that it is not equitable to lay upon house owners the burden of proving that they hold their grants under special conditions and ought not to be subjected to the provisions which convenience and military requirements dictate in a locality which has been set apart for military purpose. This the necessity for securing house accommodation for the military and civil officers of the government is essential, but we have endeavored to safeguard the interest of the house owners and to remove any reason for complaint on the part of the latter. It will be observed that in the bill, the cantonment rules have at present been indefinitely referred to in as much as that prepared and published for criticism some time ago. They have not yet come into force. It is intended, however, to bring them into operation before the bill becomes law. These rules will provide fully for the matters dealt with the bill so far as grants made under them will be concerned. Consequently, I may point out that the operation of the bill will be practically restricted to the past grants only. Now, this is a very important statement given by the general. He says that this bill will be applicable only on past grants. Now, what is past grants? Were these grants under the GGO 179, or these old grants was subjectively called past grants? Now, what does the further part says? The statement of objects and reasons deals fully with the important clauses of the bill, and I need not at the present moment say more than the proposed legislation is greatly required, and that I believe it will place the relation of landlord and tenants in military cantonments on an equitable basis, and will be valuable remedial measure for what is now a most unsatisfactory state of things. The motion was put and agreed to. Major General Sir Edwin Collin introduced the bill, moved that the bill and statements of objects and reasons be published in the Gazette of India in English and in local official gazettes and in such other languages as the local government may think fit. So the motion was put and it was agreed. The council adjourned in Shimla. This was done by J.M. Macpherson, Secretary to the Government of India, on 4th November 1898. This speech was given to me through an RTI letter. Friends, we need to understand. Now, what does the House Accommodation Act or the Bill 1899, finally, when it became an act in 1902, rebrushed in 1923, that this issue of pass grant could be either prior to the Governor General Order number 17 of 1836 or Governor General Order number 260 of 1838 or Governor General Order 14 of 1827 or any other Governor General passed for either three presidencies, or should be this past grant be from 1864, as after the making of the Cantonment Act 1864, no grant could be either given within the presidency town by other cantonment magistrate or outside the presidency town by a lone cantonment magistrate. Now, what does under section 14 of the bill says? Act says, if a house in respect of which, if a notice is issued under section 6 or 7, is shown to the satisfaction of the local government or is provided by a decree or order of court of a competent jurisdiction to have been erected. One, under any conditions, rules, regulations, order, which were in force in Bengal prior to 8th December 1864 and conferred on the owner the option of offering the house for sale to the military officer, applying for its appropriation for his occupation, or to the East India Company or to the government. Now, this section clearly reads that that is why bungalows were being purchased by the government. Further, that under any conditions, rules, and regulations or orders which were in force in Bombay prior to 1st June 1875 and conferred such an option as described in clause A, then the owner will have the option of either complying with the notice or offering the house for sale to the military officer in whose behalf the notice was issued, or to the government. Two, the owner elects to sell the house and such military officer or the government is willing to purchase it, the amount of purchase money to be paid shall, in the event of disagreement, be determined by a committee of arbitration that has any case like this taken in any of the cantonments we can refer. Now, here, what does the Union of India? It does not come clean to the Honorable Court. We, the residents, who are the proprietors or the property owners in these cantonments, We neither fall as in Punjab in Bengal Presidency or Bombay or Madras. So where does the House Accommodation Act's applicability come in places where it was not notified? Because Madras and Punjab cut dates are not given. This is where the Honorable Court needs to understand that prior to this cut dates of the respective presidencies, Bombay and Bengal, these dates then should be registered with the cantonment magistrate and under the various cantonments act. It becomes extremely important for the honorable courts to understand the House Accommodation Act. No cut date for Madras Presidency or Punjab Province. So why? The There were no rules for Punjab Province as stated in CLA Rules 1937 at page 254. The above explains the position with regards to rules and regulations in force in cantonments prior to the passing of the Cantonment Act 22 of 1864. After the passing of this act, the powers of making rules as to the occupation and use of government land in cantonments and its resumption by government was given to the local government, while section 17 and 19. But no such rules were forthcoming for Punjab in these cantonments. So the government of Punjab was addressed this, and it appears from their reply that they did not frame any rules under the first three clauses of section 19 of the act quoted above, but they followed the Bengal regulations. So all old rules and regulations were superseded by the Cantonment Code of 1899, and the code has in turn been superseded by Cantonment Land Administration Rules in 1925. So where are we going, friends? It is very important. There is a letter number 76 AD or 4 of 7th January 1938. Further, there is a Secretary of State of India speaking on 13th September 1933 via letter number 33549 oblique 11 oblique 212 LC, stating that House Accommodation Act 1902 oblique 1923 overrides all rules and acts made under the Cantonment Act and codes. So, is anything left? If we are a part of the Cantonment House Accommodation Act, no Cantonment Act or Cantonment Code or CLA rules is applicable on us. So, friends, I've been generally telling everybody why I've been speaking, because we are old grants. We were revenue free grants, could be termed as Lakir Raj grants under the Bashai orders or the non Bashai orders. Please understand. Get in touch with me. Thank you. Good day.